This video will provide a general overview and introduction to alternative dispute resolution, sometimes referred to as ADR for short. As a part of the litigation process, parties often wish to avoid the court process in its entirety and look to alternative ways to resolve the matter, ways that are cheaper and less time-consuming. After viewing today's video, you will be introduced to various methods of alternative dispute resolution, such as arbitration and mediation. Arbitration is one form of dispute resolution. It is a private, judicial determination of a dispute by an independent third party. That third party may be an attorney or retired judge. In Hawaii, parties utilize dispute prevention and resolution and private companies that employ individuals that can serve as arbitrators and mediators. Arbitration is an alternative to court action and is generally final and binding, depending on the type of arbitration and what is agreed to by the parties. Some of the advantages of engaging in arbitration is that the parties can choose their decision maker. As stated previously, they can contact companies like Dispute Prevention and Resolution and choose from a panel of arbitrators. Arbitration is also efficient and convenient because the parties are working with the arbitrator's schedule, as opposed to the court's busy calendar. Unlike the litigation process, arbitration is most oftentimes less expensive than going to trial and is less expensive due to the finality of the decision and the inability to file an appeal. Mediation is a process in which two or more people or businesses discuss how they can reach an agreement on issues that affect both of them with the help of a third party called a mediator. Mediation is a voluntary process, which means at any time either party can decide to end the mediation. Mediations can be formal or take place in an informal setting, such as the workplace. In the workplace, it is common for employers and employees to discuss issues related to wages, benefits, work assignments, and other issues. When a third party becomes involved, it is a mediation. Mediators are not judges or juries. They are neutral facilitators that help parties resolve their disputes and reach an agreement. Not everyone is well suited to be a mediator. In fact, it takes certain character traits and qualities for someone to be an effective mediator. What character traits do you think make a good mediator? Let's take a couple of moments to think about what those traits might be. Good mediators are people who are neutral, intelligent, and trustworthy. A mediator is not a decision maker, but instead assists the parties in settling their dispute. While sometimes they give their opinions, they should remain neutral in the eyes of the parties and get them to mutually decide who to settle their dispute. Mediators should also be intelligent. The issues involved in mediations can range from simple personal injury matters to complex commercial litigation disputes. Regardless of the subject matter, the mediator needs to understand the legal issues and be socially and emotionally intelligent in working with the parties. Finally, it is important for the mediator to be trustworthy. The mediator is going back and forth between the two parties and communicating the position and points of view of the other party. Although the mediator agrees to keep the information a party shares confidential, it is important that the mediator be trustworthy and not reveal information that was disclosed to the mediator in confidence. Sometimes there are formal mediation processes, like during collective bargaining negotiations. When the parties are not able to reach an agreement by themselves, a mediator may be appointed to help in the negotiations. However, a mediation can take place in an informal setting as well. In these situations, just about anybody, a boss, coworker, friend, or family member, can act as a mediator. There are many benefits to choosing mediation as a method of alternative dispute resolution. Mediations are voluntary, confidential, effective, enforceable, and cost-efficient. One point of clarification. You may have heard that mediation is voluntary and non-binding. As a general matter, this is true about the process. Unless ordered by the court, the parties generally have to agree to participate in mediation. The mediation process is non-binding in the sense that the parties can stop participating in the process at any time and cannot be forced to enter into a settlement agreement. However, if the parties enter into a settlement agreement, the agreement is binding and enforceable. The mediation process typically flows through several stages. Initially, the mediator introduces himself or herself, sets the stage, and explains the ground rules for how the meetings will be conducted. Then the mediator employs a variety of methods or tactics to help the parties voluntarily reach an agreement. Finally, the mediator helps ensure that if there is an agreement, the parties understand the terms of the agreement and are committed to carrying out the agreement. Often, the mediator drafts a written document that describes the terms of the agreement. This is a visual illustration of the steps in the mediation process. It starts with the introduction where the ground rules are laid. Then the parties tell their story. The mediator then identifies the positions and underlying interests of the parties. This can be done in a joint session or in a separate session where the mediator shuttles back and forth between the two different rooms where the parties are meeting. At some point during the mediation, the mediator identifies alternative solutions and presents them to the parties. This is where the most valuable work of the mediator occurs. Once a tentative form of agreement is reached, the term sheet is revised and then presented to the parties for signature. The term sheet contains the basic terms of the agreement reached at the mediation, but oftentimes the parties are asked to draft a comprehensive settlement agreement after the mediation. This concludes today's video. Please proceed with completing this week's activities.